Hello and good morning friends, welcome to the CEC-UGC live lecture. Dear friends, with our ongoing series on copyright and trademarks, we have so far conducted one lecture, and in our previous session we have discussed on law relating to trademarks. That was an introductory lecture, and I would tell you all that today also we would be talking more on laws related to trademarks, and this is in the continuation with the previous session. So dear friends, for this very session we have once again with us within our studios Mr. Ashwini Sewal. Mr. Ashwini Sewal is Assistant Professor in IP and Data Security Laws, Faculty of Law, University of Delhi. His immense experience would definitely help us out in knowing more and more about the trademarks. So without wasting any time, I would like to welcome our guest Mr. Ashwini Sewal. Mr. Sewal, welcome to the UGC lecture.
Thank you very much. Welcome viewers. Well, see, trademark law basically, is used for the purpose of establishing and making it clear that trademarks are the indications and the marks for the purpose of indicating the source and the origin of the goods or of the services. This is what we learnt in our previous lecture. What we are going to discuss today would be in continuation of our earlier discourse, where I'll be talking about a few more intricacies and few more things that will get covered in the trademark law and that gets covered in the trademark law. Well friends, as I mentioned, the trademarks, as the name suggests, are the marks or indications used in the course of trade. And what is important here to be noticed is that the marks or indications are used always in the course of trade, only then they are called trademarks. If they are not used in the course of trade, then in that case that particular mark or an indication will not be called trademark. Friends, what we are going to cover today in our today's discourse is very important thing, that is the meaning and the conceptual basis of the trademarks. As far as the meaning of the trademark is concerned, I have dealt partially as to what is the meaning of the trademark. I'll be covering the later part of the meaning of the trademark, where we will take up certain definitions, and those definitions will be able to help us to understand the meaning of the trademark properly. Apart from that, the conceptual basis of the trademark law, as to why do we need a trademark, what is the reason or the use of the trademark, its usage, its potentiality, these are to be discussed by all of us in this session. Apart from that, friends, I'll discuss some important provisions of the Trademarks Act 1999. I mean its overall composition, as to what the Trademark Act 1999 covers in its ambit and scope. The next thing that we are going to cover, what is the purpose of the Trademarks Act 1999, as to why it was brought into the existence, what was the necessity and the need, and how is it serving the traders, the enterprisers, the owners of the trademark. What all it covers to facilitate the trademark owners, to facilitate the enterprises, to facilitate the users of the trademark by purview of its provisions. The next thing would be the important definitions covered under the Trademarks Act 1999. Well friends, there are many definitions given under the definitional clause, that is section 2 of the Trademarks Act, but I won't be covering all the definitions. I'll pick few definitions for our today's session. Rest of the definitions we will cover as and when the need and the desire would occur and accrue. The next thing, what are the important themes to be seen when one is introduced to the trademark law? This would remain our discussions area and arena today, and some important sections of the trademark law. Well friends, before jumping directly to the definitional part or to the purpose of the Trademarks Act, or say its important provisions, one more important thing that I would like to highlight at this juncture, that is about the distinction between the trademark law and other IPs. What is the interface between other IPs of the trademark law? How do we distinguish between the copyright and the trademark? How do we distinguish between trademark as an IP and the patent on the other hand as an IP? Similarly, what is the distinction between design law and the trademark law? So there lies an interface between all these different kinds of IP. We have to understand what is that distinction. Well friends, coming straight away through the definition discussed elaborately by me in my previous session, which makes it clear that a trademark is a sign capable of distinguishing the goods or services of one enterprise from those of other enterprise. This is the definition given by WIPO. Friends, WIPO is primarily an organization which is called World Intellectual Property Organization, and its work is basically to facilitate and to disseminate the knowledge about intellectual property. So the definition provided by WIPO of a trademark reads that it is a sign capable of distinguishing the goods or services of one enterprise from those of another, and that is the purpose of a trademark. When one uses a trademark, he by that use, that enterprise, that individual by that use tries to impart the logo, the sign, the device, the mark, the indication used by him into the mind of the end consumer. And when the end consumer keeps it in his mind because of the repeated use of the trademark, because of the repeated advertisement of the trademark, because of the repeated marketing of that trademark, because of the repeated branding of that trademark, it remains inculcated into the mind of the end consumer, and that is how it gets imparted forever into the mind of the consumer. So that sign which is capable of distinguishing those goods, how does those goods gets distinguished? Because a sign is used on those goods, affixed on those goods, or maybe used with those services by the owner of those services, by the provider of those services or manufacturer of those goods, which remains imparted into the mind of the end consumer. And that is how it serves a very important function. The trademark serves a very important function of establishing a trade connection, of establishing a connection into the mind of the consumer about the origin of the goods, about the service provider of the services, about the manufacturing of the goods, and there are few more things as a corollary which gets into the mind of the person, that is the reputation and the goodwill. I mean, one when goes to the market to buy a product, he initially goes by the name of the product, that brand of the product, which we call a trademark in a legal parlance. In common parlance, that particular thing is called as a brand, but in the legal parlance, the lawyers call it trademarks. Marketers call the same thing as a brand name. For example, Coca-Cola is a brand name for the marketers, but for a lawyer, Coca-Cola exists as a trademark. So the one who goes to the market, the consumer, the end consumer goes to the market, he sees the bottle of the beverage having or possessing Coca-Cola as a trademark written on it. And Coca-Cola, friends, as you remember, or if you might remember, it is written in a red color in a very stylized font. That font is a peculiar font written used by the Coca-Cola manufacturers of that beverage. And there is a color combination, it comes in a red color. So we keep it in mind always, and whenever we buy or we go to buy, whenever we buy and we go to buy a bottle of a beverage, of a soft drink, we identify either by the brand name or maybe by the shape of the bottle itself, because shape of the bottle itself can be given a trademark protection. So see, the function here that the trademark is serving is the function of establishing some sort of a relation, some sort of a connection into the mind of the buyer with reference to the product in question, which is a soft drink bottle in that case. Well friends, this connection gives few more additional advantages, few more additional benefits to the consumer. The consumer goes by mere brand, mere trademark of the bottle, and he is assured of the quality, he is assured of the taste of the beverage, he is assured of the reputation and goodwill of the beverage, of the soft drink. So that is the function that the trademark plays, that the trademark basically dispenses. Apart from that, from the point of view of the trader, from the point of view of the marketer, the trademark does another function, the function of distinguishing his goods from the goods of another. If you compare a Pepsi bottle and a Coca-Cola bottle, the Coca-Cola written on a Coca-Cola bottle along with the shape of the Coca-Cola bottle, which is a peculiar shape in which the beverage is contained, if we compare this shape with the Pepsi bottle, which comes in a differently shaped bottle having a peculiar shape altogether, with the word written Pepsi in stylized manner and in different colors, you compare these two and you can easily make out, even without bearing those marks, one can make out that this bottle is a Coca-Cola bottle and the another bottle is a Pepsi bottle merely by the shape of the bottle. So that is how, see, the trademark functions for the trader as well, so that his goods can be easily identified and recognized by the end consumers. His goods can be easily and properly recognized and distinguished from the goods of another, so that the consumers may not get deceived and cheated and may not get duped, and they may not end up buying a wrong product, they may not end up buying unintended product. So from the point of view of the traders or marketers, trademark has got a very good potentiality and a function. On the other hand, from the point of view of a consumer, trademark serves a very important function and it helps the consumer out in identifying the goods, in keeping knowledge into the mind of the person about the appearance of the products of the trademark which has been used on those products, so that they can keep it in mind and they are assured of the quality and reputation of the goods or the product as such. So these are the two components in which this trademark functions, or two trajectories in which the trademark functions. Well friends, we saw the definition provided under the Trademarks Act 1999 under section 21ZB, which reads, a trademark means a mark capable of being represented graphically and which is capable of distinguishing the goods or services of one person from those of others, and it may include shape of goods, their packaging and combination of colors. Well friends, the important aspect of this definition to my understanding is the aspect that the trademark is first of all a mark, and the definition of the word mark is also provided under section 21M, which reads that the mark means a logo, a device, a symbol, color combination, shape of goods, packaging, etc. It is an inclusive definition. It is an inclusive definition, and inclusive definition here means there can be more things to be included, there can be few more things to be included in the definition of the word mark. And if that mark is capable of distinguishing the goods over which that mark is used from the goods of another person, then it tantamounts, or say it rises to the dignity to be called a trademark, to be given a protection under the Trademarks Act 1999. Well friends, one noticeable aspect that I forgot to discuss in my previous discourse as far as this definition is concerned, it in the later part covers that even the shape of goods, color combinations, packaging, they are also be called marks or trademarks. Even the shape can be given a trademark protection, a color combination can be given a trademark protection, a packaging can be given a trademark protection. Friends, this later part of this definition is a new inclusion of the 1999 Act. Earlier to 1999 Act, we had a Trade and Merchandise Marks Act of 1958 operative in India. In that particular act, in the definition of the word trademark, this later part of this act, this particular provision was missing. I mean to say that in the 1958 trademarks definition, shape of goods, packaging, color combinations were not included as trademarks. It is a new entry or new additions are there in the definition of the trademark. And friends, the rationale behind these additions are simple and clear, that in today's world where new forms and new patterns of trademark are coming to fore, are being registered, even the shape can become a potential trademark and can distinguish the goods or services of one person from those of others. In having said that, in the example given by me, where I compared the two soft drinks bottles, Pepsi and Coca-Cola, I told you that even the shape of these two bottles are different. Even the shape itself is potential enough, is capacitated enough to be given a trademark protection. So these new things were purposely added, and the purpose, if seen from a perspective of marketers, is questionable and debatable. I would like to draw the attention of my viewers that all this shape thing or all these new entries were able to manage themselves into the text only because of the lobbying done by big big industrialists. For example, Coca-Cola almost lobbied for 20 to 30 years or 3 decades in many nations to finally get the shape of Coca-Cola bottle registered as a trademark. And that particular effort or endeavors done by Coca-Cola or lobbying done by Coca-Cola got reflected in the Indian Trademarks Act 1999 also through the definition 21ZB, where trademark includes even the shape of goods, packaging and combination of colors. Friends, the next thing that I am going to discuss here with you is that the trademarks are intellectual property rights. They are intellectual property rights because they are, at the end of the day, intellectual creations of the persons, of the owners of those trademarks, of the users of those trademarks. Well, friends, a very simple thing to understand and comprehend, that whenever you start a business entity, whenever you start any kind of a service to be provided to the people, to be rendered to the people, you always give a name to that particular service. You always try to give a name to the goods which you are going to sell and offer to sell. For that matter, there is a need of creativity and intellectual application of the mind of the person to come up with a unique name. There can be several names which can be given to your business, to your service or services provided by you. But I urge to all my viewers or all prospective business entities who are listening me out here, that they must always come up with the fanciful and arbitrary words. They should not use generic words. They should not use descriptive words, because generic words are those words of everyday use. For example, you cannot use a word milk for your dairy business. You cannot get it registered. Your trademark with the name milk will never see the day of light. Reason being that it is a everyday's usage word. It is a generic word for those goods in relation to dairy products. So the point is, whenever one gives a name by applying the intellectual mind or intellectual application of mind to the goods or services provided by that person, he or she should always come up with a fanciful word. He or she should always come up with a arbitrary word. I'll tell you what does the fanciful word mean, what does this arbitrary word mean in my later discourses in a detail. But at this juncture, you just keep it in mind that you need to always give a thought before trying to start off your business with a trademark, with a brand name. And that brand name must not be descriptive of your business, must not be, generic in relation to the goods or services provided by you. Well, friends, this Trademarks Act 1999, as I promised that I am going to tell you what all Trademarks Act 1999 covers in its ambit and scope. I have discussed in my previous discourse that the Trademarks Act in its purview first of all tells what would remain the subject matter of the trademark. The subject matter of the trademark is what? A mark, and the definition of the word mark is given under section 2(1)(m). Well, friends, another thing that is the most important aspect of the Trademarks Act 1999, or most important feature of the Trademarks Act 1999, is the qualifications for obtaining a trademark. But friends, you would be surprised to know that trademark definition is given, but the definition or say the qualifications for obtaining a trademark is nowhere provided. Only restrictions or prohibitions which would refuse you to register a trademark or say which would restrict and obstruct you to get a trademark registered with the trademark board are provided in the 1999 Act. Well, the point is that the definition is provided of the word trademark, and in the definition itself there are some qualifications interspersed. We will have to refer or infer those definition or those qualifications interspersed in the definitional clause itself. In the definitional clause, especially provision number 21ZB and 21M of the Trademarks Act, where it is categorically written that the trademark must be capable of distinguishing the goods of one entity from the another entity, and it must have the capacity to be graphically represented. So these are the two qualifications. Another important aspect of the Trademarks Act 1999, as mentioned by me, is that it primarily tells you, and it categorically tells you some of the prohibitions for refusal to register the trademark, or grounds for refusal to register the trademark. Those grounds are given under section 9 and 11 of the Trademarks Act, friends, and those grounds are very important to discern and elaborate and decipher here, which will be deciphered and elaborated by me in a separate session altogether. Maybe 2-3 sessions I'll take on those refusal grounds given under section 9 and 11, because section 9 and 11 are what are the core of this Trademarks Act 1999, are the soul of Trademarks Act 1999. Well friends, apart from that, section 27, 28 and 29 are of much importance, wherein it is provided as to what are the remedies available in case of violation of the trademark. Section 27, then section 29 and section 30 covers it appropriately, covers it adequately, the question of remedies. It tells us what constitutes infringement, it tells us what does not constitute infringement, it tells us what are the remedies available in case of violation of a trademark. Then friends, jumping before to section 27, there are some procedural provisions provided under section under section 18 to 23. I mean 5 to 6 provisions are there, helpful or providing an assistance in understanding the procedure for obtaining a trademark. Procedural formalities. Well friends, one important thing that I would like to highlight here, that that procedural portion ranging between section 18 to 23 is alone not sufficient to tell you what are the procedure for obtaining the trademark. We have to read this procedural part along with the trademark rules of year 2003. The trademark rules are more exhaustive and explanatory as far as the procedural formalities for obtaining a trademark is concerned. Friends, now I believe we have come to a stage and a step where we need to understand as to how a trademark is used and can be possibly used on the goods or on services. For use, we have certain provisions, or say some definitions provided under the Definitional Act itself, which tells us explicitly as to what would constitute the use of a trademark, as to how a trademark can be used. One can say at this juncture that if one wants to register his trademark into the minds of the consumers, if one wants to market his trademark into the market, then he or she needs to always use it first. Use of a trademark is a sine qua non, is an essential thing necessarily to be done by the prospective user of a trademark, or you can say by the user who proposes to use its trademark on the goods or services. So what does use constitute? That I will take up in a very exhaustive fashion, wherein I will gonna take you to a case study which is expanding the definition of the word use, or expanding or say enlarging the definition of the word use, which makes it very clear and aptly clear that use does not only mean affixing a trademark onto the goods or using a trademark with the services. Use has got a very unconventional definition too by its enlargement done by purview of that case law of the year 1996, and that case law has heralded altogether different regime or era where we understand and construe the use of a trademark on goods and on services. Friends, one more thing that I believe is to be noted and discussed at this juncture. If you see this third, fourth point on this slide, the word trademark is used and written in 3 different styles, wherein trademark is used without a space, then trademark is used as trade space mark, and then trade colon mark. Well friends, you will find it written in this manner interchangeably, but kindly don't get confused and perplexed by this kind of a usage. We can use the word trademark interchangeably. It does not make any distinction, it does not draw any kind of a complexity in it. It is to be used in any manner written here, and you will find it written in this manner or maybe in another manner in the different literatures available on trademark. Maybe in another country's literature you will find trademark written by providing a space between the word trade and the mark, or in another country's literature you will find the trademark word written by using a colon between the word trade and a mark. But don't get confused, don't get perplexed by this use. It is one and the same thing, there is no distinction. Well, it is just a clarification for you guys to understand. Well, generally one more confusion remains into the mind of the consumers. As it is an introductory lecture, I should always try to clear the preliminary doubts into the minds of the consumer at this juncture. Trademark is sometimes called as a service mark. The distinction between trademark used to identify services is as follows. Trademark which is used for services is called a service mark. On the other hand, trademark which is used on goods is called a trademark. That's the only distinction. I mean, the service mark is a mark which is used with the services. Let us take certain examples which will clarify this doubt into the minds of the audience. Well friends, some of the examples of a trademark are provided here by me. As I told you, the definition of the word mark given under 2(1)(m) deciphers and clearly includes it as what? It is letter or a word or a symbol, numeral, figure, shape of goods, packaging or whatever. I mean, there are so many things. Let us take the examples of these things one by one. As far as the letter and words are concerned, they come and fall squarely in the definition of the word mark. The letter or word is the most common type of a mark. The letter marks and word marks are most common type of marks. For example, Apple, you see on your screen, then Silicon Graphics, then Netscape, IBM, NBC. See, all these are what are the examples of letter and word marks. And letter and word marks, as highlighted and said by me categorically, are the most common type of marks, are most rampant kind of marks used by maximum people, because there is no need while using the letter or word marks of applying or of the application of extraordinary imagination. Only some letters are to be put together or some words are to be put together to be used. We will see some more examples in the next session, friends. Thank you. Well friends, we saw the examples of trademarks, especially letters and word marks, which I said are the most common type of marks. These are some of the examples on your screen which are word and letters marks. These are Apple, Silicon Graphics, Netscape, IBM, NBC. Let us take few more examples of some kind of marks. See, the definition of the word mark given under the 1999 Act under section 2(1)(m) includes logos also as the trademarks. It reads that a logo can be a trademark. What is the example of a logo and what would we understand by the term logo? Let us understand it. Logos, friends, are the most common form of mark after letters and word marks, and they can be described as a design which becomes a mark when used in close association with the goods or services being marketed. Well friends, I am reading it again for your convenience. A logo can be described as a design which becomes a mark when used in close association. It is primarily a design which becomes a mark when used in close association with the goods or services being marketed. The logo mark does not need to be elaborate. It need only distinguish goods and services sold under the mark from other goods and services. These are some of the examples of the logo marks. The logo of McDonald's, this is the letter M, but this letter M is written in a different kind of a design, is described in a different kind of a design. This is a logo of a McDonald's. Then there comes another logo here. It is a design and this design is called a logo. Then there comes a logo of Apple. This logo, friends, it is not a letter Apple, A-P-P-L-E written here. It is a design used as a trademark. It's a design used as a trademark on the goods or with the services of a Apple provider. Similarly, the definition of the word mark includes pictures or drawings. It includes pictures or drawings. What do you mean by pictures or drawings? Well friends, pictures or drawings of a character or scene are often used as trademarks or service marks. Any kind of a picture used as a trademark, any drawing to be affixed on the goods or used on the goods of any scene, of any character, that can be a potential trademark, that can be given a trademark protection. For example, this picture or this drawing of a character, and this is called a Apple's automata. This is a potential trademark. It is registered and it is already in use. Then this Emerson's butterfly, friends, is also an example of a picture as a trademark or drawing as a trademark. So these examples can easily make you understand that a trademark can be given on logos, on pictures or drawings, on word or letters, and there are few more things to be included in this category or to be easily and properly, squarely fall into this category. Let us see what are those. Well, it can be a combination of letters and a design. A trademark can be a combination of letters and a design, such as, you see, IBM. Well friends, the word IBM, it is a combination of letters and it can be used merely as a trademark or by any person as a trademark, I mean the owner of the trademark as a trademark. It is what? It is just a combination of three letters, I, B and M, written in a stylized manner, and a color combination is very peculiar, is very unique. Then there comes another combination of letters, Sun. It is a trademark and a very good combination of letters used here with a peculiar design, peculiar color combination. Then there comes another example of a trademark. It is a combination of letters and colors, friends, wherein a red color is used in the background and the word digital is written. So this is a composite mark. This is a composite mark. All these are composite marks. Well friends, now coming to some more examples as to what can be a trademark, as we are right now dealing with the definition of the word mark defined under section 21M of the Trademarks Act 1999, and this section 21M reads that a mark includes shape of goods, mark includes color combinations, mark includes numeral, letter, figure, shape. We have taken examples of word and letters, we have taken examples of logos, we have taken examples of drawing and pictures. Now we are going to take an example of a slogans as a trademark. Even the slogans can be given a trademark protection, and in today's market, friends, not only the trademark is used to distinguish the goods or services of one person from those of another, Rather, some slogans are also used as trademark. Examples of strong trademarks are attached herein. You see, with the McDonald, the slogan "I am loving it" acts as a trademark. With Pepsi, the slogan "Ye dil mange more" acts as a trademark. The slogan itself is a trademark, friends, can be a potential trademark, can be given a trademark protection. So the point is, what I am trying to do is to just tell you that several things can be called a mark, and whatever is called a mark as per the definition given under section 2(1)(m) in the Trademarks Act 1999 can become a trademark subject to the condition that it fulfills the qualification attached in section 2(1)(zb) of the trademark, which says that the trademark must be capable of distinguishing the goods of one person from those of others. It means that it must have distinctive character. I am using the term distinctive character to summarize the qualification, which reads as that the trademark must be capable of distinguishing the goods of one person from those of another. I am using the word distinctive character. In nutshell, you can say one qualification for a trademark to be given a trademark protection, for a mark to be given a trademark protection, that it must be distinctive. And the next qualification is that it must be graphically represented. So graphical representation and distinctive character are the two qualifications, apart from that it must be a mark as per the definition given under section 2(1)(m). And the slogan here used in this slide can be a potential trademark, can be given a trademark protection, because slogans are also are equally protected as trademarks. Some more examples of a trademark: even the shape of a thing can be given a trademark, as read by us in the definition of the trademarks. Let us see a shape of this Coca-Cola bottle. This shape serves a source identifying function. Well, friends, I did not explicitly tell that the function of a trademark is to establish the connection of identifying of a source into the mind of the consumer. So anything can serve as source identifier. Any mark or any indication can serve as a source identifier. A word or letter can serve as a source identifier. A slogan can serve as a source identifier. A shape of a thing can be used as a source identifier. A character or device can be used as a source identifier. A color combination can be used as a source identifier. So the purpose is to identify the source. The purpose is to establish the connection of the producer by seeing or by having a glimpse of the trademark by the consumer. If he is able to do so, if he is able to establish a connection or identify a source or the origin of the goods merely by watching the mark or an indication used, the purpose gets served. Another shape you see, friends, on the slide given by me is the shape of a iPod. This shape itself is trademark protected of iPod by Apple. Maybe 2-3 decades ago they got it registered as a shape trademark. It is a unique kind of a shape, and a unique kind of a key is used, or say you see this key or say buttons are used for use of this iPod. So that shape itself is a registered trademark and can act a proper and appropriate example of a trademark. Well, friends, we have now come to the next point as to what are the legal qualifications or what should be the legal qualifications for obtaining a trademark. Well, friends, it needs to be a mark first of all within the definition of the mark. I am summarizing what I have stated just now in last 30 or 20 minutes. Then it must be represented graphically, another thing. Then it must be capable of distinguishing the goods or services of one from the another. Then must not hit by prohibitions of section 9 and 11. So these are the legal qualifications to be fulfilled for obtaining a trademark. First and the foremost qualification, it must be a mark within the definition. It must be represented graphically, must be capable of distinguishing the goods or services of one from another, that is to say it must be distinctive, or say it must possess the distinctive character, then must not hit by prohibitions of section 9 and 11. Well friends, after having introduced you to the basic qualifications or legal qualifications to be seen, and the some examples of our trademark or the meaning of the word mark, I have, to my understanding, reached to another stage where I need to make you understand as to how a trademark can be used and what would constitute use of a trademark, how a trademark can be used, and why we are so concerned about the use of a trademark. Because use of a trademark is a sine qua non, is an essential thing to be shown and proved by the person proposing to use the trademark. But there are some unconventional, or say unusual manners coming to notice, where the use of a trademark is done by the concerned person, concerned entity, and held by the courts as a proper use of that trademark. I will discuss those also. Let us see as to where this word use of a trademark has been made a mandate in the Trademarks Act 1999. When it comes to use, the question comes, what constitutes use of a trademark? So the next thing that comes to mind, what are the sections that covers use of a trademark? The section 2, which is a definitional clause, friends, especially under its subclause 2b and c, and section 29 of the Trademarks Act under subsection 6 defines and uses the word use of a trademark, which is a sine qua non, which is an essential thing, which is must to be proved and established initially for making a use of the trademark. You can say that is the heart and soul of a trademark law, that the person whosoever is proposing to use a trademark, he must use it, he must show that it is in use or it is going to be in use. Well, as far as under section 2b and c is concerned, use can be made by affixing the mark on goods or by using the trademark with the services. When you offer the services, you use or give it a name. That use is a proper use, can tantamount to be constituted to be called a use of the trademark. And use is necessary. Without using it, you cannot get it protected, you cannot get it registered. So either by affixing the mark onto the goods, for example, Coca-Cola uses the word Coca-Cola by affixing the Coca-Cola word in that peculiar color combination with that stylized font on the Coca-Cola bottle. That use is a use on those goods by affixing it. Or it may be by just offering those services by that name. So use can be done in two trajectories, in two perspectives, in two components, on goods, affixing on the goods, or by offering the services by the name of the trademark. Then there comes another thing, and this is unconventional thing. This is unconventional thing. Can a trademark be used through advertisement? No affixation of a trademark is done on the goods. It was never offered, no services were offered with that particular trademark in the market, but it is always used in an advertisement. Can that tantamount, or can that be called a use of the trademark as per the Trademarks Act 1999? Well, this would remain our question for query and quest, and this question will to my understanding is to be addressed at this juncture, because that has kind of overhauled the meaning of the word use, and this question whether a use through advertisement is a proper use has changed the entire jurisprudence of the Trademarks Act 1999 as far as the meaning of the word use is concerned. Well friends, the case law that comes into the question into my mind at this stage and while discussing the use through advertisement is N.R. Dongre versus Whirlpool Corporation 1996 case dealt by Supreme Court. I will take you to the fact sheet and then I will discuss as to how use through advertisement was held as a proper use by the Supreme Court of the country, and that has changed the entire discourse of the trademark law in the later years. Well friends, let us first before discussing to the fact sheet of N.R. Dongre versus Whirlpool Corporation, let us see the definition provided under section 2 of the word use. Section 2 reads, unless the context otherwise requires, any reference to the use of a mark shall be construed as a reference to the use of printed or other visual representation of the mark. If you print the mark on any goods, if you make a visual representation of that mark on the goods or with the goods, then that is construed as a use, unless the context otherwise requires. This is what section 2 says. Later it reads that any reference to the use of a mark in relation to goods shall be construed as a reference to the use of a mark upon or in any physical or in any other relation whatsoever to such goods. So use in relation to goods here shall be construed, use in relation to goods friends shall be construed as a reference to the use of a mark either upon the goods or in any physical or in any other relation whatsoever to such goods. If you physically put the mark on the goods, that construed as a use as per this definition. If the user of a trademark just uses that mark upon the goods, it construed as a use, referred as a use of a trademark, or in whatsoever manner to such goods if he uses that mark. So by using the word whatsoever, this definition makes the nature of this definition as inclusive. There can be new manifestations and reflections of the word use or of use of a trademark in relation to goods. It can be used in some unique manners, in some unique methods which are today not known, which are today not into the understanding of the person, or are not into the mind of the person, but they may tomorrow start using those marks in relation to the goods, can be given or called use of a trademark. Then friends, the another thing that comes into the comes to be discussed at this stage, use of a trademark in relation to services shall be construed as a reference to the use of the mark as part of any statement about the availability, provision or performance of such services. So when you use a trademark in relation to services, the law says that use shall be construed as a use if the trademark is used as part of any statement making the services available, as part of any statement making the provision of those services available, as part of the statement making the performance of those services in the market. So in any of these manners written here, the use of a trademark in relation to services can be construed as a use by making use of a trademark in the statement from where you make the goods available, from where you make the services available, by using the trademark in the statement which provides the provision for those services, or by making the use of the trademark in any statement which provides the performance of such services in the marketplace. So that tantamounts to use in legal manner, in legal parlance as per section 2. Then friends, another provision or another legislative reflection and demonstration, that is section 29(6), which reads, for the purposes of this section, a person uses a registered mark if in particular he affixes it to goods or the packaging thereof. A person uses a registered mark if in particular he offers or exposes goods for sale, if in particular he puts them on the market, if in particular he stocks them for those purposes with that particular trademark under the registered trademark, or offers or supplies services under the registered trademark, that tantamounts to use as per section 29(6). So it is just a reiteration what was said in earlier provision section 20, section 2, which is a definitional clause, but section 29 just reiterates to emphasize it that affixing the trademark on the goods or on the packaging thereof tantamounts to use. Offering or exposes goods for sale or putting the trademark on the market or stocks them for those purposes with that registered trademark tantamounts to use of a trademark. Then there comes the third thing. It says a person uses a registered trademark if in particular he imports or export goods under the mark. So the importation and the exportation of goods under the mark also amounts to use of a trademark, also termed as a use of a trademark. You as such do not affix the trademark on the goods. You do not physically put the trademark onto the goods. You just import those goods with a trademark. You export some goods with a trademark. That is suffice to constitute use of a trademark made by you, and you can be given a trademark protection. Then there comes unconventional use, friends, in the last. A person uses a registered trademark on business papers or in advertising. On business papers or in advertising. So, use of a trademark on business papers. It is not a use of a trademark onto the goods or upon the goods. No trademark has been physically put on the goods. No trademark has been used for the availability of the services in a statement or something like that. It is merely used on business papers, it is merely used in advertisement. That also tantamounts to use of a trademark. So, whosoever is desirous of obtaining a trademark, he or she has to show or say has to propose to show that he is going to either affix the trademark onto the goods, or he is going to offer some goods or exposes goods with that trademark by physically putting those trademark onto his goods, or he may show that he is going to use a trademark on the in the business papers or through advertising. If he or she does that, then he can be granted a trademark protection. Another important feature, as far as another important aspect as to why the use is to be understood in a very meticulous manner, whenever anybody violates a right of one person, in that case also, as per section 29, it is to be seen whether the wrongdoer has used the trademark of the legitimate owner unauthorizedly. In that case, use is to be seen. Whether the wrongdoer has used it by affixing the trademark onto his goods, whether he has used it in importing or exporting, whether he has used it onto the business papers or in advertising. So, if he is found to be using the trademark, the wrongdoer is found to be using the trademark in either of the manners written under section 29, then he can be held liable for making an unauthorized use of a trademark, and he can be called an infringer of that trademark. Well, friends, I believe I have been able to convey as to what would constitute use and what are the intricacies to be seen, or say what are the nuances to be seen when it comes to use of a trademark. I will continue my discussion with a few more things in my next session, where I will be discussing, some more important aspects of the trademark law, and the next session to my understanding would revolve on the refusal grounds or say for prohibitions of the trademark registration, wherein I will tell you about section 9 and section 11 in detail. When we will be discussing section 9 and section 11 in detail, we will again see the importance of the word use defined under section 2(b), c and under section 29(6) of the Trademarks Act, and there only I will discuss the fact sheet of N.R. Dongre versus Whirlpool Corporation decided by the Apex Court of the nation, where use through advertisement in India done by Whirlpool Corporation, wherein the fact is that the Whirlpool Corporation never existed in India, no market for them existed in India at that point of a time. They were not manufacturing their products in India at that point of a time. Their products were not available across the counters and across the shops in India at that point of a time. They were just merely advertising their electronic appliances in some journals, in some reputed journals in India, no prospective consumers were there, as the goods were not available in country. Still, the apex court decided it into the favor of the Whirlpool Corporation and upheld their point that their use of Whirlpool trademark through advertisement constitutes use as per the Trademarks Act 1999, and if any wrongdoer unauthorizedly using a Whirlpool as a trademark with his or her goods shall be made accountable and liable for that kind of unauthorized use. We will take this case law in detail in my next session. Thank you so very much, friends, for kind and patient hearing. See you next time. Thank you very much. Have a good day.
With this note, thank you, sir. Thank you so very much for giving us a very, very resourceful session, I would say. Here, with the help of different examples, we have tried to understand about the laws relating to the trademarks. And dear friends, we believe that this session would have appeared to be very, very beneficial. If you have any queries or if you want to give your feedback regarding this particular lecture, then you can mail us at info.cc@nic.in. And very soon, this lecture is going to be uploaded on YouTube for you, so that it becomes easier for you to get in-depth knowledge, as well as if you want to access the previous session that also have been uploaded for you on YouTube, and a series on intellectual property right is already there for you. So keep watching these lectures, as well as keep giving your feedback to us, because your feedback is very, very important for us, so that we could make our delivery more beneficial for you. So we would be meeting again very soon, and would be discussing on another aspect of laws relating to trademarks. Till then, take care. Goodbye. Thank you, sir. Thank you so very much.